one of my law school friends invited me to something, and then she was like, "Bring your finest turtleneck." It's like, oh shit, she ate me up with that one. That was a good one.
That's so funny.
Shout out to Lenny.
God.
Guys, welcome back to Further Study, where we are doing more bar questions with our sound guide to see if you can pass the bar exam. If you have any questions, comments, or legal concepts you want us to cover, feel free to email the show at furtherstudy@hemmettlaw.com. We'd love to hear from you. Without further ado, let's jump into the questions. Homer conveyed property to his daughter Lisa, quote, "for as long as the property is used for residential purposes, but if it ever is used for commercial purposes, then to my son, Bart," unquote. Lisa has lived on the property for 5 years and now wants to sell it to a buyer who plans to open a restaurant. Bart learns of this potential sale and objects. What interest does Lisa hold in the property?
Wow. I mean, a pretty significant one, if I'd say.
Yeah.
I don't know. I don't know what interest refers to. I know I'm going to learn about it legally in just a sec, but it sounds like she violated whatever contract Homer set up.
Here's your answer options. A, life estate. B, fee simple determinable. C, fee simple subject to condition subsequent. And D, fee simple absolute.
Well, isn't this just a lovely one?
I literally have not taught you any of these.
I'm hold on. I think I'm gonna go with the dart landed on C. So I don't know. What is there any insight into any of this? Fee simple.
If I give you any insight, I give you the answer. So
Okay.
I'm afraid there's no hints.
I'm just gonna go with fee simple. Let's go with fee simple absolute D.
D?
Yep.
Incorrect, but it is fee simple. It's B, fee simple determinable. The grant uses durational language when they say for as long as, creating a fee simple determinable in Lisa that will be automatically divested if the property is used commercially.
Yeah.
In this case, was shifting interest to Bart. So a fee simple determinable is created by durational language that causes the estate to automatically terminate on the happening of a stated event.
Gotcha.
Right? Allowing a designated party like Bart, through a shifting interest, to take possession.
Man, yeah, that makes sense.
Jerry negligently left his car running in his driveway while retrieving mail. 10 minutes later, Kramer, an intoxicated driver, crashed into Jerry's parked car at high speed, causing both vehicles to explode. The explosion killed Newman, a jogger on the nearby sidewalk.
Oh no, Newman.
Evidence shows that if Jerry had turned off his car, Kramer's crash would have caused only minor property damage without explosion or fire. However, Kramer's blood alcohol level was 3 times the legal limit, and he was driving 60 miles an hour in a 25-mile-an-hour residential zone. In Newman's wrongful death action against Jerry, which causation test should the court apply to determine Jerry's liability?
I mean, no causation. That's crazy. Well, he had his car on. Yeah, sure. I was driving like Tiger Woods.
Yep.
Directly into the back of his car. But his car was on. That feels whatever is the one that says that Kramer is 100% at fault.
Here's your answer options. Yeah.
Okay.
A, the but-for test, because Jerry's conduct was a necessary condition for the explosion that killed Newman. B, the concurrent cause test, because both Jerry and Kramer acted simultaneously to cause Newman's death. C, the substantial factor test, because multiple causes contributed to Newman's death, and the but-for test would be inappropriate. D, the proximate cause test, because this involves foreseeability rather than factual causation.
I mean, it's just so funny to imagine a world in which this guy's just drunk as shit, just running straight into the back, and then it's like, well, but his car was on. It's C. It's C. I don't need to theorize anymore. It has to be C because
it's A.
It's A?
It's A because the but-for test applies to determine factual causation when the defendant's conduct was a necessary condition for the harm, even if other factors contributed, because the truth was Newman didn't die because Jerry was drinking. Newman died because evidence showed if the car hadn't been on, he wouldn't have died.
But Jerry's just parked with his car on?
Well, because think of it like liability doesn't rest with the first domino.
Yeah.
It rests with the chain of causation the entire along the way. That doesn't mean people can't have contributory influence and can have partial liability. It is still mostly the drunk driver's fault. But the reality remains that the drunk driver only killed him because of this other guy's action.
Wow.
The but-for test asks whether the harm would have occurred without the defendant's negligent conduct. It is the default test for causation, in fact.
Yeah.
Here, would Newman have died without Jerry leaving the car running? No. Right? The evidence shows that no explosion or fire would have occurred if the car had been off. And so death would not have occurred, and therefore that really matters. Thus, Jerry's negligence was a necessary condition for the causation, despite Kramer's primary role.
Negligence. I'm appalled. Negligence. That he demonstrated, like, is it that Jerry left his car running and then like walked inside?
Well, remember,
like,
in the call to question, it says Jerry negligently left his car running in the driveway while retrieving mail. Now, I think the flaw of this question is that it's pretty hard to imagine a world in which a reasonable person would find grabbing mail briefly while leaving your car running negligent.
Yeah, exactly.
But it's given to you in the question. So basically, what you're pointing at is that you would be defense counsel or you would be plaintiff's counsel, and you'd be like, you'd be an attorney. I'm losing my analogy here. You'd be an attorney and be like, come on, it's not negligent.
Yeah.
to get mail while your car's running in the driveway.
Yeah.
Right. But that was given to you in the call and the question, so you must respect it.
Gotcha.
So but that's one of the things that plaintiffs' attorneys argue over.
Yeah.
Is that, like, was this necessary causation negligent for the circumstances at hand? And if it was, then that's a pretty significant factor.
Yeah. Wow. That's, okay, it makes sense now. Once you, like, but it's just a crazy, like, and it was negligent.
Yep.
He was being negligent.
He was being negligent.
That's a setup.
Well, there's the reasonable person test in negligence, which is to say, would a reasonable person under the similar circumstances do this? Or for professional negligence, is this within the custom of their professional practice?
Yeah.
That could be for doctors, lawyers, accountants, etc.
Gotcha.
But the problem with the reasonable person test is that the reasonable person who acts in a reasonable basis 100% of the time doesn't exist. It's a legal fiction, right? But it's the least worst test we have that works on average.
Yeah, exactly.
But you're right. Like, there's real problems with it, of which you just observed. In a breach of contract case, Ariana alleged that Ethan failed to deliver goods as promised. During trial, Ariana's attorney offered evidence that after the alleged breach, Ethan sent a letter stating, quote, "I apologize for the delay. I'll give you a 20% discount on your next order to make up for this." Ethan objected. Quote, "This is an offer to compromise and is inadmissible under FRE 408. Ariana's attorney responded, quote, "Your Honor, I'm not offering this to prove liability. I'm offering this to prove that a contract existed between the parties, which Ethan has disputed. How should the court rule?"
This is a pretty dense one, I feel. I don't know if I'm going to have the best indication until I hear the answer options.
Here's your answer options. A, admit the evidence without limitation because it's being offered to prove the existence of a contract, not liability. B, exclude the evidence because offering a discount is always an offer to compromise that is inadmissible. C, admit the evidence with a limiting instruction that the jury may consider it only to prove the contract's existence, not liability for breach. And D, exclude the evidence entirely because FRE 408 prohibits all uses of settlement communications.
Ooh. It does feel like settlement, like communication. I don't know. I love D because it has a rule. And also, it feels like then no one would settle. Like, you're setting yourself up bad in court if you can just, like, be like, hey, they offered this and this and this to settle out of court.
That
Don't
means
they look guilty?
It. Yeah.
I think I'm going to go with D.
Well, that's incorrect. It's C. Admit the evidence with a limiting instruction that the jury may consider it only to prove the contract's existence. So in this case, it would be pretty impossible to prove the foundation of the case if they didn't use it just to
set that up.
Yeah, so in this case that's necessary, but you hit exactly on the policy considerations. FRE 408 prevents the use of doing exactly what you said. You can't offer it like, hey, I'll offer you $1 million to settle this now, and then you can't use that against them later in court to tell the jury, they offered $1 million. They can't. And
look how bad they look.
Yeah, exactly. And similarly, you can't use evidence of a correction as evidence of wrongdoing in the first place.
Gotcha.
So, like, if there was an unsafe warehouse and everyone wasn't wearing safety equipment and someone gets injured and then all of a sudden they start wearing safety equipment while the lawsuit is pending, the
can't
plaintiff
be
the plaintiff can't go to the jury and be like, look, they made all these changes, because that would be essentially punishing people for fixing the problem. Right. And the courts don't want the courts are ultimately there to safeguard public safety. And so they don't want people using settlement negotiations or good faith efforts to get into compliance as evidence of wrongdoing in the first place, or else the incentive would be to never fix anything.
Yeah, exactly.
So under FRE 408, compromised offers are inadmissible to prove liability, but may be admissible for other purposes, such as proving the validity of or existence of a contract when admitted for a limited purpose. FRE 105 requires a limiting instruction upon request.
Gotcha.
So there, like, sometimes it's unavoidable.
Yeah,
basically. But the courts, like courts here in Washington, also have ER 408, which does the exact same thing. It prevents you from admitting offers of compromise and letting it be considered at trial.
Okay. I mean, yeah. That feels like a good call.
Because you want people to settle.
Yeah, you want people to settle. Or lightening the court load feels like a good thing.
Yeah, it feels like for judicial economy. That's exactly the interest. Ted walked into his apartment and discovered Robin in bed with his best friend Barney. Ted immediately flew into a rage and grabbed a baseball bat from the closet. Without hesitation, he struck Barney in the head with a bat, killing him instantly. At trial, Ted testified that he had never suspected Robin and Barney were involved and was completely shocked by what he saw. The prosecution argued that Ted should be convicted of murder because he used a deadly weapon.
Whoa.
Of what crime should Ted most likely be convicted?
Oh, I mean, killing, I'll tell you that much. But what terminology are we dealing with?
Here are your answer options. Yep. A, first-degree murder, because Ted used a deadly weapon with intent to kill. B, involuntary manslaughter, because Ted did not intend to cause death. C, second-degree murder, because Ted intended to kill but did not premeditate. And D, voluntary manslaughter, because Ted acted in the heat of passion upon adequate provocation.
I feel like that feels old-timey. D feels old-timey to me. I think I'm going to go with C, because it's like second-degree murder. It was in the heat of the moment. Like, it's not like he waited outside. I think I'm going to go with C.
That's incorrect. It's D.
It's D. Wow.
It's D, because Ted acted immediately upon discovering Robin and Ted. I'm going to fucking kill myself. I'm going to kill myself. Okay. Because Ted acted immediately upon discovering Robin and Barney together, a form of adequate provocation, and killed in the heat of passion with no cooling off time.
Wow.
The offense is voluntary manslaughter. So you and I have talked about this before, which is to say heat of passion is recognized in a small number of instances, most traditionally discovering your spouse in bed with another man.
Wow.
The law recognizes. And you may remember me talking about this under the context of gay panic.
Yeah, that's what I was thinking of.
Heat of passion. Heat of passion, one of the qualifications of heat of passion is that if someone comes out, some courts, not all, and only in the past, as far as I know, recognize that like someone coming out to you as gay, the emotional reaction qualified as adequate provocation, and therefore, and then lowered the punishment you would get from like first degree murder to manslaughter, which I think is ridiculous. It's I bring us back to that example because it's a perfect example of how courts are 20 years behind for better or for worse. Right, and that's one of the worst ones. But here, finding your spouse in bed with another man, I think the law attempts to recognize that that's like. That's pretty crazy. Now, if he had like walked out of the room and taken 2 or 3 minutes to think about things, and then he had come back in and then beat him to death, that would void. There's no cooling off time permitted.
Wow.
An intentional killing is reduced to voluntary manslaughter when committed in the heat of passion due to an adequate provocation before a reasonable person would have cooled off.
Wow.
Yeah. Which is adequate provocation. Catching a spouse committing adultery is a classic common law example. Provocation for a reasonable person. It can extend beyond that, but like spousal abruption is like the number one classic example.
Super popular.
Yeah, exactly. Yeah. Ted was shocked and acted immediately. That's the test for provocation.
He saw it and he beat him to death with bat. Oh man.
Now there's sometimes questions like if the cooling off period is like 10 or 20 seconds. Here he struck without hesitation, leaving no chance for a reasonable person to regain self-control. It's a reasonable person test.
Yeah.
So that's where everyone will be arguing. So like, could a reasonable person have cooled off from your spouse cheating on you right in front of your eyes?
Wow.
Which would suck, I admit.
But man, the cooling off, it's so funny to just like, no, well, he acted immediately.
Yeah.
Like, he should be less guilty because he was more prone to violent instincts.
Well,
like, it's
I mean,
just
like,
so funny.
It's so funny.
Like,
it sounds ridiculous when you say it out loud, but I do want to at least try and give the law some credit. That they're recognizing human fallibility.
Yeah. Yeah. I know. I just think it's funny. It's like
if you kill him
the
quickly,
more hot ex-UFC fighter with CTE, like finds his wife in bed. That guy's going voluntary manslaughter.
If you kill him super quickly, you get a discount.
Yeah, exactly. That's the premise.
Which is kind of funny because like there it's not quite the same thing, but there was a time in torts law where you couldn't, like in the olden times, where you couldn't sue for wrongful death.
Whoa.
It was only for injury. Like in tort law, once you were dead, you couldn't recover because there was no injury.
Yeah.
Which this was a very long time ago. And so what would happen is it would incentivize you finishing the guy off. Just like double tapping him. There was a time in law when they hadn't fully figured that out yet in civil law, and wrongful death wasn't fully a thing. And so you run a guy
I've got
over.
to cover my tracks.
You run a guy over with your car
Yeah.
in the civil context, then you better back up over him again to make sure you're still already going to jail for injury. But there was a time in tort law where they hadn't recognized that we don't want defendants incentivized to finish the guy.
Yeah. Lawyers don't want you to know this one simple trick.
Defense counsel, just one weird tricking their way out of liability. Yeah, but to be very clear, it has not been that way for like a very, very, very long time.
Yeah.
So just wanted
double taps.
Yeah, no double tapping. Don't get legal advice from YouTube.
Yeah.
John provided lawn care services to several homes on. I'm gonna kill myself.
I'm gonna
Fetch me my finest gun. One of my law school friends said to me the other day, invited me to something, and then she was like, "Bring your finest turtleneck." I was like, "Oh shit!" She ate me up with that one. That was a good one.
That's so funny.
Shout out to Lenny.
Oh my
God.
Okay. You talked about your lawyer doctor friend the other day on the podcast, and one of the comments was, "Lawyer doctor, I'd hate to be that guy's cousin."
I will say the glazing has got to be crazy because Hamza is in residency as he's in law school. Lawyer doctor, your auntie is never letting you live that down. And every immigrant household knows what that feels like. But he's wicked smart. Make no mistake.
Wicked smart.
All right, here we go. John, after I'm done killing myself, John provided lawn care services for several homes on Wisteria Lane. Gabrielle was traveling abroad for 3 months. Without any request or prior communication, John mowed Gabrielle's lawn every week while she was gone, believing she would want the service because he had done yard work for other neighbors nearby. So just other neighbors.
Yeah.
When Gabrielle returned, John presented her with a bill of $1,200. The reasonable value of 12 weeks of services at $100 per week. Gabrielle said, quote, "I'm not paying. I never asked you to do this, and I've already arranged for my neighbor Bree to handle the lawn for free." John sued Gabrielle for $1,200. At trial, John proved that Bree never showed up and that Gabrielle's lawn would have become overgrown and violated Wisteria Lane HOA rules without John's services. Is John likely to recover from Gabrielle?
No, he can't, right? Like, I mean, it's just like, well, I made a reasonable assumption that you would want my services. Like, I mean,
this is like Hormozy level shit.
Yeah, exactly. I know, yeah. Well, it's like Apple installing YouTube on your phone and then being like, "Money, please." Like,
oh god, I forgot about that. Well, this is like he read $1 Million Deals one time and then went berserk. So here's your answer options: A, yes, based on restitution, because Gabrielle received a benefit that would be unjust to retain without payment. B, yes, based on implied in fact contract, because Gabrielle's acceptance of the services created a contract. C, no, because John was an intermeddler who provided unrequested services. And D, no, because Gabrielle had already arranged for free lawn care services.
I mean, so I don't know. I mean, I'm stuck between C and D because I just don't know whether the free lawn care services are relevant. You know what I mean? To like the call of the question. I think I'm going to go with C.
Going with C?
No. Let's go with D because it does specifically call out that he had arranged for free lawn care. And then this guy's like, well, I was mowing the whole neighborhood. Might as well. Like, it'll be easier for me.
Not the whole neighborhood, just some other neighbors.
Oh, just some other neighbors?
Yeah.
Oh, it's D.
D?
Yeah.
Incorrect.
Oh.
You were correct. It was C.
Oh,
it was
C.
C earlier.
Dang.
Since John provided services without any request or reasonable expectation that payment would be expected, John is a mere intermeddler who cannot recover in restitution, even though Gabrielle received a benefit. So you're absolutely correct. There actually are some nearby adjacent circumstances in which it would be reasonable. So, for example, if the HOA specifically said you must contract with someone, that maybe then there's an argument to say that, like, hey, you had to contract with someone and he was the only one and he was doing the whole neighborhood.
Yeah, but even then, would it be like, could you be like, well, I kept you from getting a fine, like, give me money?
No, well,
like,
I mean, that's when it would be like if he was doing the whole neighborhood, and she had received notice, and a couple of other things.
He would have had to, like, specifically deny.
Yeah, or if she had been home the whole time, and she had been watching him mow the lawns, and she did nothing. Sure, she didn't ask, but also she didn't stop him or indicate no. Then there is an argument to be made that then there's reasonable services for reasonable benefit. But she was gone for 3 months, so there's no argument to be made that she asked or implied. There's an implied there are circumstances of implied contract. The law tries to recognize situations of equity where, like, hey, you've been mowing this guy's lawn for 10 months. And you have to. You also additionally have to under HOA, and you knew he was doing it. And and this is the fair and reasonable market price for doing so. Then under those some circumstances, but here she was out of town. And you can't just do shit for people and then demand payment. So, like, I think the tricky thing here is that under contract law, these situations where whether or not something is reasonable or a benefit or whether or not they knew, that's all factual. So you'd have to go through a whole lawsuit
just to
obtain that. So those lawsuits tend to be very rare, and also because in general people don't do free things for other people that often. So it's not. This is very much a black letter question flying in the face of practicality. Here, restitution requires that service be requested or provided under circumstances creating a reasonable expectation of payment. A volunteer or intermeddler who provides unrequested services cannot recover, obviously. Bob posted a flyer offering $500 to, quote, whoever returns my lost snail, Gary. The flyer was not addressed to any particular person and indicated payment upon return of Gary. Rest in peace, Gary. Patrick saw the flyer, spent 2 days searching, found Gary, and on his way to Bob's house, called him to say he had found Gary. During that call, Bob said he had changed his mind and revoked the offer. Patrick nevertheless delivered Gary to Bob the same day. Can Patrick successfully recover the $500 from Bob for returning Gary? This is what we call, in bird culture, a dick move, by the way.
Your prized pet, and then you're not willing to fork over the cash for it
after he'd searched for 2 days.
I feel like I've wondered that before. Like when you see like the posters of a missing tabby, it's like, are they actually gonna pay $500?
Here's your answer options. A, yes, because Patrick can recover only if Bob has promissory estoppel because he relied to his detriment. B, no, a reward offer is an invitation to bargain and requires a signed written contract under the statute of frauds. C, yes, for a unilateral offer, beginning performance can make the offer irrevocable and full performance constitutes acceptance. D, no, because Bob effectively revoked the offer because Patrick completed performance, so no acceptance occurred.
Shoot. This is promissory estoppel is a fun word. I just have to know.
A fun pair of words.
Fun pair of words.
Two, in fact.
Two words. Yeah, I think C.
That's correct.
Yay,
C is absolutely correct. In a unilateral contract, once the offeree begins performance, the offerer cannot revoke. Full performance completes acceptance, so Patrick's return of Gary constitutes acceptance and entitles him to $500. So this is actually why unilateral contracts is sort of why when you see an advertisement, while supplies last, offer is limited. Because if you think about it, an advertisement has all the conditions of a contract, right? It has an offer for a good or service at a particular price at a particular location. So in theory, it was argued that that was a unilateral contract, but we invented a legal fiction called an invitation to negotiate or an invitation to bargain. Which is basically, as long as you qualify the offer, it's no longer considered a binding contract.
This is the listed price for now.
Yeah, exactly. That's why they always have that key language in the advertisements, because otherwise, in theory, you're making a binding offer to literally every single person, because it meets all at least on paper, it meets all the qualifications for the formation of a contract.
Could Mr. Bob have gone while supplies last, while cash supplies last.
Yeah, while cash
on
supplies
the
last. I mean, I think I just wanted to draw that parallel because it's why we see that language so much. Here, performance technically was not delivery; it was finding Gary. And so he had already found Gary when he called.
Yeah.
And then that's acceptance.
Yeah.
Right? A reward flyer is a classic unilateral offer to the world, acceptance by performance, returning Gary.
Nice.
Patrick began performance, and he spent days searching, and as soon as he found him, the offer became irrevocable as to his performance specifically. Patrick's delivery of Gary completed performance and thus accepted the offer in full.
Nice. Hell yeah.
Lindsay and her friend Paris were driving to a party when Lindsay, who was intoxicated, insisted on taking over driving duties.
Oh.
Paris reluctantly agreed. Lindsay immediately began speeding and driving erratically. Fearing for her safety, Paris grabbed the steering wheel and tried to slow the car down. This caused Lindsay to lose control and the car veered into oncoming traffic. The car struck another vehicle, killing the driver, Nicole. An accident reconstruction expert testified that if Lindsay had been driving normally at the speed limit, the collision would not have occurred even with Paris's intervention. However, the expert also testified that Paris's grabbing the steering wheel was the immediate cause of Lindsay's losing control. In a prosecution of Lindsay for vehicular manslaughter, can Lindsay argue that Paris's intervention was a superseding cause that breaks the chain of causation?
Wow.
This is criminal context.
Yeah. So Lindsay gets in front seat, goes Tiger Woods mode.
Yep. Big Tiger Woods mode. Yep.
Yeah, Tiger Woods mode activated.
And we're not talking about the golfing, just to be clear.
Yeah, or the other stuff.
We're
talking
you're right.
specifically
Yeah.
about
Specifically
the drunk driving.
Yeah. Dude, I hope Tiger's legal team does not see this.
Yeah.
Allegedly
drunk driving that allegedly put a car in a ditch.
Make a note to double our media liability coverage.
Exactly. I think regardless of how much Tiger Woods was her hero, I don't think that Paris's grabbing of the wheel
had too much. Here's your answer options.
Yeah.
A, yes, because Paris's grabbing the steering wheel was the immediate cause of the accident. B, no, because Paris's intervention was a dependent intervening cause that was reasonably foreseeable. C, no, because Lindsay's intoxicated driving was a but-for cause of Nicole's death. And D, yes, because Paris's intervention was an independent act that was not foreseeable.
It kind of feels like an independent act that she couldn't foresee. I think I'm going to go with D.
You're going with D?
Yeah.
Incorrect. It's B. No, because Paris's intervention was a dependent intervening cause that was reasonably foreseeable. So that's a really fancy way of saying is if you start driving fucking crazy, your passenger might try to take control of the vehicle because you're about to kill them.
Yeah.
It was a dependent factor, which is to say you started driving crazy first.
Oh, yeah.
It wasn't you didn't lose control because the passenger tried to stop you.
Yeah.
You lost control because you started driving crazy.
That's a good I like that rule.
And on top of that, it's kind of reasonable for people around you to react to your individual actions and start trying to so like the law recognizes that like under certain circumstances you can act to save yourself.
Yeah.
But this would probably be an argument that they would make is that like if they didn't have that expert that said this definitely would have happened, they would have argued that like, hey, it's not the drunk drivers that are the problem, it's the drunk crashers.
Yeah, exactly.
And we're not one of them.
It's the sober passengers of the drunk drivers.
Yeah, exactly. Give those drunk drivers a bad name. And as we know, I'm not a practitioner of the arts, so we'll have to ask someone else about that. But a dependent intervening cause that is reasonably foreseeable as a response to the defendant's conduct does not break the causal chain and does not relieve the defendant of criminal liability. And particularly not of civil liability, though that probably would be a fight in the civil courts.
Yeah. Okay. Yeah. They start driving like Stan from the Eminem song.
Yep.
You have a right to try and grab the steering wheel.
Well, not a right. I don't want to overstate it because there's a reasonability test. So in this circumstance, you could go too far. So like if it wasn't erratic enough and it was just normal driving, and then you grab the wheel and crash, be careful, right? You play with fire. It's an escape hatch. It's not ironclad. Yeah. So just be careful about that. But the idea is that the law lets you reasonably react.
Yeah. Okay. No, that makes sense. Nice. That feels very just. Yeah. You know what I mean? Like there are just these certain times in the bar questions where I'm like, wow, law is about preserving justice for all parties. This is awesome.
It's a balancing act between what's good for individuals and what's good for society.
Yeah.
When shit cuts against plaintiffs, it's usually because there's an even greater interest to the public good. So like, for example, or when they intervene, when the state intervenes in right to contract, it's because there's usually a public policy decision overarching. So like, for example, a great example that we deal with all the time is in pre and post-nup agreements or in cohabitation agreements.
Yeah.
You cannot mandate that someone go to couples counseling before you divorce. You cannot add any barriers to the divorce process. You can't prevent someone from filing for divorce.
Wow.
Even by agreement. And that's because the law recognizes that, like, hey, there's a public policy interest.
Yeah.
It's a right to get divorced. You always have a right to separate from someone.
Yeah.
You can't waive that through contracting.
Yeah.
So that's a perfect example of the state coming in and like being like, hey, there's a larger interest here than private.
Yeah,
negotiation.
that's like a barrier. Like, and then, that makes so much sense.
Yeah, and that's a pretty benign example, but there's examples in like every field of contract law. Like, for example, you can't contract to induce someone else to break a contract. So, for example, in the BlackBerry movie,
I'll give you $1 million if you sign right now.
I am not moving to Canada. We are not having this conversation.
the dude goes into another guy's office and is like, I'll give you like millions of dollars to break your contract with Apple. You can't, that's not enforceable. You can't go in and give someone money.
Like I gave him $10 million and he didn't even break his contract.
Yeah.
Okay.
Exactly. And it's also technically legal for him to accept that because employees usually have a certain level of fiduciary duty to their employers if they're under contract, right? And so that's just a perfect example of like how that doesn't work in real life.
Yeah. Whereas usually, like if you follow European soccer, they give the club $120 million in order for the player to break their contract, and then they step outside, and then they get that.
Yep, exactly. But guys, that was it for this week's of Further Study Bar Questions. Thanks so much. Remember, next time you want to watch, or if you're binging more of these, there's a quiz on YouTube if you want to play along with us. If you have questions, comments, legal concepts you want us to cover, email us at furtherstudy@hemmettlaw.com or leave a comment down below. We read all of them. You guys constantly impress us with how witty and funny you guys are. So please share the show, like, subscribe, hit all the good buttons, and we'll see you very soon.
Later.